Hi, everybody. On the telephone, this is Rob McKenna with Secretary of State Reed.
Good morning, everybody.
And we have some folks who are here with us in the room. So why don't we go ahead and get started with questions from people who are on the phone.
Rachel, can you just give us the legal rundown of exactly what happens now?
What happens next is that the district court in Tacoma will take up the question of the referendum 71 petition specifically, because the Supreme Court's ruling was on the lower court's original ruling that no petitions for any ballot measure, any referendum or initiative for that matter, can ever be released. But as we told the court, we know that specific petitions might be treated differently, and the R71 petitions were never actually specifically considered by the district court. So there'll be a trial at which the proponents of blocking disclosure will have an opportunity to try to prove that there was enough evidence of threats, harassments, or reprisals to keep these specific petitions from being released. Now that the general question of whether petitions as a rule are public records or not has been settled in favor of the Public Records Act.
As Secretary of State, the Chief Elections Officer of the state of Washington, I'm delighted with this 8-1 decision of the United States Supreme Court because we have had firm convictions in this state about the importance of having open records, open government, transparency in government, and believing in the public's right to know. Ever since 1972, we've had one of the most sweeping open record acts in the nation. And I think this has helped our political process. Our campaign contribution expenditure records have been public records since that time, and petitions that people have signed to put minor parties in the ballot have been open records since that time. And this would have been a really bad setback for open government in the state, so I'm just delighted with this ruling.
Okay. Other questions on the phone?
Bob, this is Tom Bonsu with Public Radio. Can you talk generally about kind of your argument and how much of it the Supreme Court upheld?
The Supreme Court's opinion, the main opinion of in this case, which was authored by the Chief Justice, tracks our arguments quite closely. In particular, they find that there is an important state interest, there's an important public interest in preventing fraud and detecting fraud and error by allowing ballot measure petitions to be released to the public. They cite the evidence that we brought up in our briefs and that was brought up in friend of the court briefs by 20 states and by groups of private individuals, pointing to example after example of fraud and error that have been detected by public review of ballot measure petitions around the country year after year after year. And we think that was one of the most important findings of the court, and it tracks our brief exactly in that regard.
Had a question, follow-up for Sam. Do you think this ruling will change the frequency of initiative petitions or the subject matter of initiative petitions in Washington State going forward?
I do not think so. The citizens of the state of Washington have had the civic courage that Justice Scalia referred to when he was questioning the person who brought this case. I remember he had that great quote, "The fact is that running a democracy takes a certain amount of civic courage, and the First Amendment does not protect you from criticism or even nasty phone calls when you exercise your political rights to legislate or take part in the legislative process. You're asking to enter into a whole new field where we have never gone before," unquote. And I think that's the underlying principle of this case.
Is there a role for the legislature here at all to act, or is this strictly something that can be handled in the court, meaning this idea of exemptions to the public disclosure law? Do the plaintiffs have to involve the legislature at all to get what they want?
Sure. The legislature could decide that ballot measure petitions, referendum petitions, are not public records. They could exempt petitions from the Public Records Act explicitly. I think that would be bad public policy, and I think it's highly unlikely they would do so. But disclosure of ballot measure petitions is a matter of statute, a matter of state policy preference. It's not a constitutional requirement.
Mr. McKenna, with all the attention that this is getting now,
Yeah.
some people didn't really think about it when they signed a petition. Now
Right.
they know, boy, my name's going to be out there, my address is going to be out there. Are you worried? We heard from the secretary, but do you think this is going to hurt the petition gathering process?
No, not really. As a matter of fact, the same concerns were raised when campaign contributions were made a matter of public record, and they're routinely disclosed. The fact that your voter registration information is a matter of public record, how many elections you voted in, and so forth. You know, that can all result in people choosing not to participate in the election process. But the court has held that even though a few people may be discouraged, the overwhelming public interest in transparency and in fraud detection and the integrity of our election processes overwhelms the possibility that a few people might choose not to participate because of disclosure. This is a landmark case because for the first time in history, the Supreme Court has ruled on what it means to sign a petition for a ballot measure. They've never done that before. They've weighed in on regulations concerning gathering signatures, but they've never before considered what it means to sign a petition. And they came down squarely in favor of transparency, of public disclosure, of protecting the integrity of the election process in this ruling.
I want to congratulate Attorney General Rob McKenna and his really outstanding team. This is my second time at the U.S. Supreme Court with him. First time was the top two primary. I am deeply impressed with the legal work they do on behalf of the citizens of the state of Washington, and I want to congratulate him on a wonderful victory at the U.S. Supreme Court.
We had a very strong team. We have the best Solicitor General in America in this office and a very strong team working with her, so it's quite gratifying to see an 8-1 decision in a case of a first impression like this. So Sam, thanks, and thanks to your office. They helped us prepare for this case by understanding in detail how public disclosure works around ballot measure petitions, and those very issues came up during the oral argument. So thanks to their help and your help, we were very well prepared, and it's a pleasure to work with you.
Thank you.